away with this case. And now Judge Henderson know he got 30 days to either he gonna dismiss the case or he gonna send it to the appeals court. Point blank.
Is there a way I can go and find out whether they claim they sent it out to my house or not?
Well, either you can call the court or you can make a personal appearance. Because if it's not been sent by regular U.S. mail by now, and today's what tomorrow's the 1st. Yeah. I think it's time to go for the motion to dismiss the entire charge. I think you need to apply for a transcript. Anyway, just for the record, just put a press to be in for the transcript.
Isn't there a charge?
Yeah, it depends. It could be a charge. And then again, he might just want a certain portion of the transcript, or he might want the whole transcript.
And is this audio or is it written, really typed it out?
Ask for a copy of the audio and the actual trial transcript. Just be thinking, a lot of people know those audios, those CDs, only $2.50.
Oh yeah.
That's it.
The audio is only $2.50.
$2.50. And then if you get a transcript, it's 50 cents a page.
That's a lot more though, isn't it? A lot.
Yeah. 50 cents a page. You might have 30 pages.
So you better off just getting the
audio. DVD.
It's the same. It has the same weight.
All you gotta do is put it in there and play it. Then you can create your own transcript. Cause you won't need the whole actual transcript. Just key stuff what the judge said and what the officer said, and that's what you attack on appeal. Because what did the officer say? How he established that you ran a stop sign?
Based off his visual judgment
of you not crossing the entire stop sign.
He claimed that I stopped in the middle of the intersection, but then I asked him, how could you possibly know that when you said that I arrived at the intersection before you did?
Right. And what did he have to say to that?
He said that when he saw me, I slammed on my brakes in the middle of the intersection, and I explained to him the reason I did that because he sped up so fast. I had already come to a complete stop behind the stop sign and proceeded to go, and he sped to the stop sign so fast, I thought he was going to T-bone me, so I slammed on my brakes in the middle of the intersection to stop a second time to give him courtesy. And I also asked him, if you claimed I was speeding as well, right? And he said, yeah. And I said, so why didn't you give me a ticket? He said, because I was being generous.
Right.
I was like, so I asked him, were you being generous because you couldn't establish me speeding in court because you didn't have a radar gun out to clock me, just like there's no way you can know whether or not I was at the stop sign first or if I ran or anything. This is all hearsay.
Right, and this is going to boil down to manifest weight of the evidence and sufficiency of the evidence. There's two elements, manifest weight and sufficiency of the evidence. And that's what you're going to show on appeal, that the officer failed to show either one of these elements in this criminal case.
What evidence of what?
Manifest weight.
So what's that?
It's the manifest weight is the more credible evidence that can't be disputed. That's what the state got to prove.
Gotcha.
So sufficiency of evidence is more technical. Like when they use radar, they can bring that sufficiency in.
Or like a camera.
They may say they got a camera or use a radar gun or some other device that they may use to prosecute a case. Because normally when you go to court, they're going to prosecute it, and they're going to say, well, we have sufficiency of the evidence.
Right. Gotcha.
But the manifest means whose testimony is more credible of to the point of what could be true and what can't be true based on the circumstances. How can they state that for instance, if a police officer struck you with a billy club, that you wouldn't be hurt. Now, whose testimony going to be credible? Yours who took the beating, saying that you're injured, or the officer that said well, you couldn't have been injured, even though he wasn't nice there? Right. Now, what juror in their right mind is going to disagree with the manifest weight when both parties agree that you was hit he was hit, and you suffered damages? Now, how can they state that you wasn't injured? And then when the manifest weight goes to deliberations, how could the officer state this man wasn't injured? How could he state the car crash or broke his leg wasn't the reason that he can't walk today? That's manifest weight. It's not a possibility at all.
So manifest is logical, and sufficient is technical, math-based. We can prove because of a device, recording device, you might have heard something, or you video something, and they can bring that in. They can see you run a stop sign with their camera, or see you speeding. If 20 people say you fired a gun, and then they got the bullet and the residue on your hands, that's manifest weight. 20 people ain't gonna say the same exact thing. Right. So it's the way you fight a criminal charge. And again, there's nothing in the revised code that we found showing even if you had went so many feet past the stop sign, that it constitutes you running a stop sign. Because running means completely through it on the other end of the intersection. Right. So I would ask the officer, okay, if I had went 5 feet beyond the stop sign and backed up and restarted, would that constitute running the stop sign? Because I never completely ran through it. Right. Those questions that you could ask him. And again, how many other stops have you made where you claim the person casually broke the plane? That's where the subpoena Dukas 7 come in. Of all your tickets you filed for the last 2 years concerning a traffic stop. Then it always boils down to credibility. What the officer, because you ain't got to prove nothing. The state got the burden to prove that you ran the stop sign. So it ain't the fact that you ran it. It's the fact that they got to prove that you ran it. You just sit there. Give your testimony of exactly what happened. And then the trier of fact got to state, well, if you ran halfway through it, then that didn't constitute that you ran a stop sign. Because you got to look at the context of the word. Ran a stop sign, not ran partially through a stop sign. Because the revised code or the ordinance got to be strict, and it says one thing. You violate the law under 7144 when you run this stop sign. Now they can't go back and change the
charge
legislation. I mean the charge is there. You gotta realize one thing: when the charges come out, they give them a handbook. If you go to City Hall one day, just go and sit one day. We're gonna pass this ordinance. Everybody in favor? We're gonna make 7144 violation of city ordinance stop sign. Everybody agree? Yeah, agree. Boom, 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 boom. Anybody opposed? No. Next. They flip the next page. Next ordinance. And they keep going down the line.
So when they doing this? I mean,
they have new ordinance coming in like every week.
So who they saying this in front of?
City commission. All you gotta do is flip it on there. And then if you got a problem with one of those ordinances, then you go down there and tell them why we think this ordinance is a violation of the Constitution, and then here's why. Here's why. Because based on where this particular light or stop sign is positioned, it's gonna be easy to violate this law. So y'all need to rearrange the stop sign or the city ordinance so people won't get trapped. Or they might have